Government. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 12th, 2026. We have 5 bills on the docket. We're going to start off with Senator Carrozza with Senate Bill 976.
Thank you, Mr. Chair. Good afternoon to all on the distinguished Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carrozza, representing Wicomico, Worcester, and Somerset counties, Maryland's coast, and I'm here to present Senate Bill 976. This local legislation would increase the salaries for the Orphans Court judges for Wicomico County from $11,000 to $16,000 beginning the next term of office. And as I know, this committee is well aware that the Orphans Court in Wicomico County plays an essential role in overseeing the administration of estates, safeguarding the interest of heirs and minors, resolving disputes, and ensuring compliance with an increasingly complex probate framework. Wicomico Court's responsibilities have expanded significantly in recent years, requiring substantial time commitments, ongoing education, and careful deliberation in matters that directly impact families during very difficult periods. And this legislation simply would provide reasonable and appropriate compensation given the increasing workload and complex responsibilities of the Orphans Court of Wicomico County. SB 976 is supported by the Wicomico County Council. And there is a letter in the file from the Wicomico Senate delegation Senator Moutz and I have sent to you, and I kindly ask for a swift and favorable report to Senate Bill 976.
Mr. Chair, thank you, Senator, for bringing the bill. By any chance, do you know how this compares to other Judge of Orphans Court of like size counties?
My understanding that it puts it on par with those other counties.
Excellent, thank you.
Just a matter of interest, how many days a week does the Orphans Court judges in Wicomico County work? Is it 1 or 2?
I would have to check on that, but my testimony reflects that their workload has significantly increased.
Right. Okay. Because I know in the larger counties, Baltimore County, it's a 5-day-a-week job. They get paid much more money in Baltimore County because they work much longer hours because there's far more cases than in the smaller counties around the state.
Exactly. So the adjustment going from 11,000 to 16,000 certainly seems reasonable with their increased workload.
Right. I just wanted the committee members to realize that Orphans Court judges to have different workloads depending on whether you're in a big county or a little county. And we have a task force right now studying the Orphans Courts, and we're going to come back with a report at the end of the year to propose making some changes. Thanks for bringing the bill.
Thank you.
It's good to see you, Senator. Your bill's fine. I just don't know if you know this, but like in Harford County, for example, our Orphans Court, or our Circuit Court judges, they just put that hat on. And then I understand, as the senator from Baltimore County indicated, some work full-time, some work part-time. I don't recall this, so you may or may not. Do Orphans Court judges, are they lawyers? Are they required to be lawyers?
They are not required to be lawyers.
Now, of course, if you're a Circuit Court judge, you are a lawyer. So do you know, and how many do you have over, for those 3 counties, how many Orphans Court judges do you have?
3, and their responsibilities, and again, it sounds like it's different in different counties. They're overseeing the administration of estates.
Right.
They're, looking out for the interests of heirs and minors.
Right.
Resolving disputes, ensuring compliance with the complex probate framework.
Yeah.
But it sounds like in the other counties, it may be more complex legal work.
I don't know, and I don't know if you ended up in an estate litigation, maybe Senator West knows, but if you ended up with a, complex litigation springing from an administering estate, I don't know whether the Orphans Court then shares that jurisdiction with the Circuit Court judge. I don't know if you know, Senator West. Is that what they do? As opposed to trying to, they're not the judges for those estate litigation cases. Is that correct?
You're right. It's complicated. There are parameters within which the Orphans Court judge must operate.
Okay. All right, well, I don't mean to put you on the spot. It's a very good bill. Thank you, Senator.
Thank you.
And let me just add that in some counties, Baltimore City, for example, the orphans court judges do have to be lawyers.
Well, same as
And
Harford County.
one of the things
Yeah.
that this commission is considering
Yeah.
is whether or not we should require all
All of them.
orphans court judges to have legal training.
Now that things are getting.
And that is not the case for Wycomico County.
Yeah, not for right
Okay.
now. Okay, very good.
Thank you. Thank you, Mr. Chair.
Senator, isn't it true that Wacomico is larger than Allegheny County?
Yes.
Is it true, in Allegheny County, they work 2 days a week, so the caseload in Wacomico is probably a little bit larger, which then justifies the number that you're looking at?
Correct.
Okay, thank you.
Thank you.
With that, that'll conclude the hearing for Senate Bill 976. We'll now move on to Senate Bill 956.
Thank you, Mr. Chairman, distinguished members of the committee, Senator J.B. Jennings for Senate Bill 956. This bill is pretty simple. It deals with Easy Pass and the tolls and the fines that many of our constituents face with those. My office, and I guarantee many of your offices, have dealt with constituents calling with regards to the number of fines they've gotten, how quickly they escalate. I know this has hit many of us, all of us. I even know of a congressman that has had to deal with this, that was given some serious fines. Some of these fines grow to $30,000, $40,000. Actually, I think somebody's going to testify. He'll tell you his worst case scenario. And people say, how's it get so quickly? You got to realize one violation is $25. And, I actually have here a toll violation. I'm not a perfect person. This is me. This was actually my farm truck during this ice storm we had back in January. I drove it down here. I didn't realize we didn't have an Easy Pass in it, and drove through and got this in the mail. $25. I paid it. But if you think about it, if you go through one time on your way to work, one time on the way back, that's $50. 5 days a week, it's $250. After a month, that's $1,000 just in fines, and it'll escalate. And people say, well, how does it get away from you so quickly? Well, if you have an Easy Pass account and, let's say your credit card expires, and you forget to check it, we're all busy. All of a sudden, that $1,000 adds up, and those fines escalate very quickly, and we're busy. I know Easy Pass sends out notices to us every 90 days. We have 90 days to act on it, but let's be honest, humans, sometimes we forget, we're busy. And they reach out to us, or they reach out to Easy Pass, and Easy Pass, sometimes they have their ability to sometimes look at that and say, hey, we will pull back some of those fines. You're going to have to pay the toll. I agree with that. You must pay the toll. It's required with the user agreement, but sometimes they'll pull back the fines and the penalties. But what happens is, if it gets to CCU, they always say there's nothing else we can do. We're sorry. It's when it gets to CCU, they say there's nothing we can do. What this bill does is it says, hey, Easy Pass, even if it's in CCU, they can notify CCU and say, hey, we've adjusted the amount. CCU, you keep the claim, but collect on this new amount. This is an issue we have dealt with many of our offices. I'm going to repeat that again. It is constant. I have worked with both the agency, that's Easy Pass, as well as Department of Budget Management with the secretary, trying to work this issue out. Again, I am not trying to get away with the tolls. You have to pay your toll if you go through it. And you should pay some, your interest and somewhat of a fine. But sometimes it just gets so egregious that you'll hear that, and you're going to hear horror stories. I think somebody's going to testify. You have divorce cases where a husband and wife, they'll get a divorce, and a wife's stuck paying this penalty. She can't register her car. What she do? She can't take her kids to school. She can't take them to daycare. So it's become an issue. But the issue with this bill is simply, all it's saying is, even if it makes it to CCU, it allows Easy Pass to say, hey, we can make this adjustment, but it stays at CCU and just collect on the new amount. And remember, Easy Pass already makes these adjustments once in a while. They have the ability to do it. They do it currently. But the excuse they use is once it gets to CCU, they can't do it anymore. It's a game over for them. This just says, hey, even though it's in CCU, we'll just allow for the adjustment. So with that, Mr. Chairman, that is the bill, and I ask for favorable consideration on it.
Do you want to do the witness, Mr. Chair?
Let's finish up with the proponents of the bill. Everyone has signed up in support of the bill, so we're going to go, I know Brett Wilson. Brett, come on up. Senator, are you voting right now? Are you guys voting?
We are.
Okay, let me, before Mr. Wilson testifies, let's go ahead and take questions if you have questions for the sponsor so that you can get back to voting. Senator Love.
Thank you, Mr. Chair. Good afternoon, Senator. Thanks for bringing the bill. You mentioned that you spoke with the administration. I don't see anything from MDTA in here. How did things end up with your discussions with them?
You don't have their letter?
I do not see it, no.
So I have a letter here, March 12th, that they have issues. I can give you this copy before I leave.
That'd be great, thank you.
My one thing about their letter that they do highlight here is they mention in here, MDTA currently has the authority to reclaim debit or debt from CCU in the event of an MDTA error. So they can already do this if it's an error on their part. So I'm just saying, hey, let's also add it if you decide to actually make an adjustment. They have concerns. I think their big thing is saying, hey, they don't want to be able to do this for everybody. And that's not what we're trying to do this for everybody. We're not trying to pull it back for everybody. And I also give this to the committee. You know, I had questions answered. You know, when you look at the amount of money that goes to CCU, just in video tolls and invoice to CCU in FY 2024 was $144 million. In civil penalty fines issued to CCU was $313 million. So it's twice as much. That's the number, the amount that we're dealing with. We're not saying that much is going to be relieved at all. It's just giving them the ability, should a constituent go to them or they work it out with a constituent. They have their issues. I mean, look, I'll tell you, one thing that drives me crazy about Easy Pass, even if you have an Easy Pass account and this toll violation I got, I cannot find it on my account. You can't find any of your violations on your Easy Pass account. It's the two don't merge. So the system's got some issues they need to work out. It's not necessarily user friendly. I mean, there's NSA computers are easier to hack than it is to get into their system sometimes if you forgot your password. But I'll give you their letter and you can read it and get what you think out of it.
That would be great. I'd appreciate it. Thank you. Thank you, Mr. Chair.
Thank you. I was on page 2. I'm looking at.
Yes.
All right. I'm looking at the language on page 2, lines 13 through 15, and the language that's being taken out of the law says, notwithstanding any other provision of law, until the authority refers the debt to central collection unit, or after the authority has recalled a delinquent account from the central collection unit, the authority may waive any portion. So it would seem, I'm curious, is that second portion that would seem like this situation, that they would have the authority to recall a delinquent, is it because it's not delinquent, this account, the situation that brought the bill before us? Because it would seem like they do have that authority to me.
I'm sorry, you're looking at the bill, page 2?
Lines 13, 14, and 15. I'm just wondering, are they just not reading it? That it says, after the authority has recalled a delinquent account from the central collection unit, are they saying that they can't recall it?
That's what they're saying they can't do, correct. They're saying the only way they can recall it now is if it's an error on their part.
So they made up their own rules, because I don't see where it says if there's an error. It says that they can recall it. I'm just saying what the law, I don't disagree with what you're trying to do. I think it makes sense what you're trying to do, but again, it's like they're reading something into the law that's not there.
Yeah.
So,
Well, I think we should codify it here.
Senator James.
Totally agree with you, Senator Jennings. And I will also tell you that I think the websites for both your Easy Pass and then any other interaction you have are woefully inadequate. And it bothers me when the rest of the world, things are very integrated, very easy to understand. You can toggle between various portals that you
Yes.
need to. So I think this is a really very harmful to our constituents, just the way it's set up, even if you don't have some kind of toll. I also think that what we probably need to better understand is just how the process works. MDOT's trying to tell us, I have no idea if this is codified, that they go to 5 notices and 90 days before, it might get kicked over to CCU. I don't know if that's statutorily required. I'm sure that's not something we couldn't modify ourselves. And clearly, if there's an error on their part, they can fix it. So there's absolutely no way they can't do it in both instances. So the other thing I just wanted to throw out there is that since the bonding authority for these, you do have to pay the tolls, no doubt about it. The
Correct.
obligations are, and that's good. So to me, some of the other aspect of this is that at some point, there ought to be the ability to look at an individual case, because when a toll gets this high, we either have somebody such a lawbreaker that it doesn't matter, or we have somebody who's really gotten lost in the system and cannot extract themselves. And once that, and they almost need debt assistance. They need help from us, as opposed to as a stone wall. So I think what we'd have to understand is, if they could even explain it to us, how the system works now and why it's not more facile and nimble and flexible to go back and forth and talk to each other. But I do think you're right. You're pointing out something that's so rigid, probably because we did not invest in the best software, the best interface, or the best customer service, that this is one of a multitude of problems with this system, because even when you want to just get an easy pass, it's not easy to work with. It's very, very antiquated. So I support trying to figure out how to fix this, whether it's this exact language. And I also suggest we should cap it. I think at some point, if you have a person who's absolutely breaking the law and could care less, no. But when you have people that are trying and can show they've been trying to extract themselves from this and make it right, I think the fines going up and up and up to an exorbitant, it's so beyond what's relevant to the violation that there ought to be a cap. It's outside anything that's equitable or fair, even when we were assessing civil penalties for something else somebody does.
I don't think credit cards can go this high.
We cap those.
I don't think credit cards can go that high.
Yeah, exactly. So, this
Yeah.
should not even be something that's allowed currently in our law, except in extreme cases, as opposed to it's the modus operandi, and unless somebody finds a good senator like yourself to have them take a look at it.
I think you're going to hear the two witnesses, both the gentleman in person and the young lady on video. I think a lot of what you brought up could be a bill
Yeah.
for next year, but I do think this bill
Yeah,
in particular
we could
is
start.
just giving them the ability, again, it's not mandatory they have to do it, it's just giving them the ability to reach out and say, okay, person X, we've gone ahead and said, hey, you know what, we've looked at their case, it's a first-time offense.
Right.
You know what, the person was out of town, they were on military orders, they didn't get their mail. We're going to go ahead, we're going to recall it, we're going to
Yeah.
adjust the fine.
Right.
It's in CCU. Let's change it from, they owe the
Right.
toll, they owe interest, but we're going to cut the penalties in half.
Right.
CCU will say, got it.
I'm with you.
We'll assess
I
that.
don't
That's all
want-
this bill's saying.
But I'm not sure whether they're trying to claim in here that they can't by law or they can't by technology.
Yeah, that I don't know.
Whichever
But
it is.
it
it's
needs to
ridiculous.
change.
It should change. All right, thank you.
All right, further questions for the senator? All right, thank you very much.
Thank you.
Thanks.
We'll
All right. We're going to hear from Mr. Wilson. Come on up. Welcome.
Good afternoon, everybody. Thank you for having me. My name is Brett Wilson, and obviously I'm a Maryland resident, a graduate student at the University of Baltimore, and I'm here to tell you about my struggles with Easy Pass. Several years ago, I relied on Easy Pass for my daily commute from Bel Air to Baltimore. Just like many of the points have been made, when I would check my account was in green, but then I would get a phone book of bills totaling in the thousands of dollars. Eventually, I was pulled over, and I learned my vehicle registration had been suspended. I spent hours calling state offices trying to figure out what happened. During one conversation with EasyPass, a representative told me my original toll would have been $900, but with penalties and fees, it had ballooned to $30,000. When I went to CCU, they told me there's nothing they could do. They can't work out anything unless I put 20% down and start a payment plan. And if I missed one payment, I would have to put down another 20% and start the process all over again. I tried to reach out to anyone that would listen, news outlets, legislators, but it seemed like it was falling on deaf ears. Most told me there was nothing they could do. Had it not been for the Baltimore Banner, I would not be here talking to you today. An hour after the story dropped, I started receiving phone calls from MDOT trying to resolve my account. My case was ultimately resolved for a tenth of the price, around $3,000, meaning there were things that we could do now to resolve these issues on a case-by-case basis, but not a system-wide level, like the senator is saying. The experience left a lasting impression. Situations like this can push people toward financial collapse and take away their primary way of earning their vehicle. I understand that our toll system is a way to generate revenue. They ultimately serve the public good for the state for the money it brings in. But when it multiplies to 10, 20, 30, or even 100 times like it was during the House hearing, it's something that you would like to know, how can we do something differently? If it were a credit card company, you'd be furious too. I'm not trying to avoid paying tolls. I simply want to see a process that reduces the confusion, worry, and administrative burden when problems occur, so that there is not a giant, overwhelming financial obligation. Thank you for your consideration.
Thank you very much, Mr. Wilson. We have one question from Senator Reviews.
Yeah, I'm sorry to go through that. I missed, what was the original bill that they stacked on all of those cars?
I think it was a lot of different things I was hearing. So when I went to EasyPass, they really couldn't tell me an exact number. That's what's so hard about this story is they tell you one thing, one representative tells me $900, but then another representative tells me it's somewhere in a couple $1,000s. It's kind of, what do I do? And then you go to CCU and you're looking at a $32,000,
Wow.
bill over top of your head.
I hope we're going to do something about that this go around. Thank you very much.
Thanks, Senator.
Thank you so much for coming down and sharing this. I just want to clarify, you believe that when you went to look at your EasyPass account,
Yes.
which is separate, as I know, because I do it too, that looks fine to you, right?
Yes,
ma'am. So you're not aware that something's amiss? You had an EasyPass? is that
I did. To your point, I
Yeah.
would go onto my account and everything was solid. I was having withdrawals coming out of my account, which EasyPass could see. But from my understanding,
Yeah.
if you have $100 in your account, but you go through $125 worth of times, that $25 goes off into a separate place where the senator was talking about, it doesn't communicate. So this is getting charged off, and then this is accruing civil penalties and late fees, and it balloons and balloons and balloons. And week after week, as you continue to go on, this thing becomes unmanageable.
Because what I understood, and
Sure.
I know I put you on the spot and you can certainly follow up, but my understanding is that I have a debit card that's on file. I think that's how it works. You have to have something, credit card. I wouldn't do a credit card myself, but, a debit card. And so you replenish it and you give them, I think they do $25. But if I went up to New York to see my kids and came back, they would go ahead and go and get a couple $100, let's say. So do you think that at some point your account, and this could easily happen to me too,
Sure.
that your account you may have gone over what you normally replenish, then when they go to your account, that's inadequate, then you're not aware of this. So then it becomes the vicious cycle that got you up to 900 and then that ballooned. And maybe what you're saying is, look, if this account was easier to see and I got online and I saw ding, 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 guess what? We've had 5 days of you in trouble here. You would have alerted and gotten on it. But by the time you caught this issue, it was ballooning in a way, and you're busy.
Absolutely.
And you're a student. It ballooned in a way that financially and time-wise, you could not bring it back into some control, especially given the responses and the way the system currently works. Is that a good summary?
I would say it's a very fair
All
assessment.
right. Thank you, Mr. Chairman.
All right, Mr. Wilson, thank you very much.
Thank you all for
sharing
having
your
me.
story. Thank you for being here. So we're now going to move on to Shawnice Turner. Ms. Turner, welcome.
Hello, how are you? I'm just going to say, my name is Shawnice. I'm a first semester nursing student. I have been greatly impacted by the video tolls I've been in contact with CCU. I've been in contact with MDTA. Um, every day I'm completely scared to take my car because my registration is expired. I can't afford the $35,000 to pay the CCU. I can't even afford the 20%. I'm gonna be honest. The CCU, my hours have been greatly impacted due to school. My mom has been letting me use her vehicle, but at this point, she needs her car back because she works for CPS. I can't afford any more $200 tickets, and officers have told me that they can impound my vehicle due to my registration being way out of date. I've written letters to Governor Westmore and Angela Oswald with no response. Also, I just want to mention really quickly that I've tried to go to court about this, but I didn't even get a date for my court for the MD for the Easy Pass. And I'm just gonna close out by saying that Governor Westmore's favorite line is "Leave no one behind," but I feel very left behind, and for that reason, I'm asking for a favorable report for SB 956. And
Ms. Turner. Hey, thank you very much, Ms. Turner. Question for you. How did you find out about this bill?
Actually, I found out about this bill. I happened to watch Fox 45, and I seen Bill Ferguson's number come up, and Governor Westmore's office and another number. I called Bill Ferguson. Bill Ferguson's office referred me to Senator Jennings, and I said, "This is crazy. Like for this to blown up like this, it's mind-boggling. I can't even really focus with school because I'm trying to figure out how I'm gonna pay $35,000, and I don't have it because I'm practically part-time at work." So that's how I found out.
Hey, well, Ms. Turner, I just want to say, look, thank you for being engaged and for following up and for actually testifying today, taking time out of your day to affect change. I wanted to say that was really compelling testimony. You as well, Mr. Wilson, but just want to say thank you for taking the time out of your day to testify and participate in this process. It's really important. So
Thank you for letting me speak.
Hey, thank you. Senator Muse has a question, or a statement.
Do you know who your senator is?
Do I know who my senator is?
Yes.
To my knowledge, I believe it's Senator Jennings' office.
Okay. Oh, wow, okay. All right. Thank you. Thank you.
Excellent. Hey, well, thank you very much, Ms. Turner. You have a great day.
You too.
Thanks. Thank you, Mr. Wilson. Thank you. All right. I believe that's it. So with that, all right, with that, that'll conclude the hearing for Senate Bill 956. We'll now move on to Senator. She's here. I can.
Fellow is going to testify, Corinne Wisman.
Corinne, is Corinne here for Senator Heddleman? All right. I'll go. We'll skip down then. We'll go to Senate Bill 984.
Yes. Do I just come up?
Sure, yes. I'll introduce the bill and we'll go next. How are you?
I signed up.
Introduce the bill and then.
Okay.
Yeah, no, you can come at the table if you like.
Okay, thank you.
All right, members of the committee, Senator Smith here to introduce Senate Bill 984 with a number of amendments that I'll explain to you that are not in the packet but reframe the bill a little bit. Obviously, the purpose of the legislation is to address issues of private detention centers being built or attempted to be built and pondered across the state. Howard County, as you may know, moved swiftly when they saw that a private entity purchased land and started constructing or reconfiguring a facility to create a detention center for immigration purposes. So the bill before you seeks to curtail that process or just to eliminate the prospect of a private detention facility in Maryland. And I wanted to be more broad than just for immigration purposes for a couple of reasons. One, because I believe it will withstand judicial scrutiny if it's more generally applied. And two is that we really shouldn't have private detention centers in Maryland. We don't right now, and we shouldn't, for a number of reasons. One is because detention facilities are something that should be subject to public oversight and public scrutiny. That's something that would fall under the purview and the responsibility of the government. They should be government run so that local jurisdictions and citizens across the state have an element of accountability and oversight and clarity into what's going on behind the walls. So private entities should not be engaged in this process in Maryland. A few years ago, you'll remember that we passed a bill that was named Dignity Not Detention, and that said that our state and local facilities would not be used to house people that were going through removal proceedings. It also said that if you wanted to create a private entity to do such, to create a facility under private, on the auspices of a private agreement, that you'd have to go through a number of hurdles of for the local zoning requirements. So we set up a number of hurdles. This bill closes that loophole and just says, listen, no private detention centers should be operational or able to operate in Maryland. So the bill will undergo a number of changes. Again, the bill makes specific reference to immigration detention. We're gonna amend that out, even though we understand where we're going as a state, because again, I think it'll withstand judicial scrutiny if it's more generally applied, and also for the reasons I stated before, we shouldn't be engaged. The state of Maryland should not have private entities running detention centers. And so with the understanding that those are forthcoming amendments, I'd ask for a favorable committee report, and I'll stand by for questions. Excellent. We have yes. Okay. Yep.
I can testify?
Sure. Yes.
Great.
Yes, ma'am.
Okay. Good afternoon, committee members. I'm Dr. Kate Sugarman. I am a family doctor. I live in Potomac, Maryland. I am a state leader and a national leader of the group called D4CC, Doctors for Camp Closure. This is a group of doctors and healthcare workers that advocates against ICE detention camps and advocates in favor of humane treatment for all of our immigrant neighbors. And I'm testifying with favorable, to vote favorably on Senate Bill 984, correct? Okay, and I have unique experience in this area because I have been reviewing hundreds, close to 1,000 medical records from ICE detention camps, and I see that people in ICE detention centers are not being provided with appropriate medical care, and as we can see, the number of deaths is continuing to rise. Just this past week or so, a Haitian immigrant died from an infected tooth. He had been complaining for over 1 month of a toothache. The tooth became infected and he died. So there's no justification for this, and there's no way that this should be happening. And the proposed legislation will make sure that there's the correct zoning and treatment. I can tell you from working with the Hagerstown community that the area of Williamsport, Maryland, where the facility, where the warehouse is, does not have nearly adequate water to supply the 1,500 people that they're talking about imprisoning there. And what I can see from my experience with the ICE jails is that people are not given, the detainees are not given drinking water. They are not provided with showers. They're not provided with nearly the water that a person needs in order to live and to thrive. So I'm urging, this is a life or death matter, so I'm urging a favorable vote on Senate Bill 984.
Thank you so much for your testimony. Senator West has a question.
Thank you, Mr. Chair. Could I speak to the committee bill sponsor, please? First of all, I want to compliment the sponsor. I think unlike some earlier bills that we got along these lines, which tried to regulate the attire of ICE agents, which I thought was seriously problematic under the U.S. Constitution, this bill, by contrast, seems to bend over backwards to try to avoid constitutional implications. And I want to compliment you for that. So I do have a couple of questions about the bill. The first sentence, or the key sentence in the bill on page 2, refers to a private entity.
Yeah.
So we have lots of detention centers in Maryland, but they're state-operated. So this would not cover any of the state-operated detention centers, correct?
That's correct, and partially because in the dignity at detention legislation we passed a couple of years ago, we've already made the policy decision not to house folks going through removal proceedings in our state and local facilities.
What about ICE? ICE is a federal agency.
Yeah.
If ICE were to purchase a big building and decide to turn it into a detention center, but ICE owns the building, would ICE be precluded by this statute from doing that?
This statute does not address that, and I think that's another policy discussion that we're definitely going to have. We have a bill in committee from the House that seeks to address that issue, and I think you're squinting towards some of the complications with that arrangement.
Right.
But if it's a federally owned land and federally operated, I think there are some challenges, admittedly.
Okay, so this bill is limited to, in its application, to private businesses that either purchase or build large facilities, which they intend to use for detention facilities, period, independent of whether they're going to house immigrants or anybody, just detention facilities, period.
That's correct. I think a more general application has a stronger chance of surviving any sort of constitutional challenge. So yes, and would obviously include immigration detention as well.
Right. So the delta, which is a little complicated here, it would be if ICE were to lease a facility from a private owner and want to put, then we'd be back into the sort of the situation of that 1920s Supreme Court case where the federal government wanted to have a man drive a postal truck who didn't have a Maryland license.
That's right.
And he was driving on Maryland roads, and the Supreme Court held that the federal government can do whatever it wants. I'm not sure the Supreme Court would still hold that today, but that remains operative law. And that would be triggered if ICE were to lease a detention facility from a private enterprise. Correct?
So that we had that discussion during the masking bill, and that case came up in that context. But I think if this passes, we are on strong footing to prohibit all private entities from operating correctional facilities in Maryland.
Right.
Where I think the complication arises is a federal-owned land, federally operated. That's one. That's more complicated.
Well, this bill literally wouldn't cover that.
Would not.
It'd have to be a different bill to cover that.
Second, even more complicated is, and the picture's more opaque here, is that if it's a federally operated, federally owned, federal land, but privately operated in the state. And I think that's a more opaque.
Yeah, I hadn't thought of that
question.
one.
That was the one that was in my mind when I was.
You had another permutation of this problem.
Because that's the arrangement that's proliferating. I mean, a lot of these detention facilities are actually privately run. It's a new marketplace that has happened across the country, and it's something that we obviously don't want to happen here.
So I think what you've got here, I don't think that this has serious constitutional implications, which helps me with this because I don't have a lot of enthusiasm for much of what ICE is doing. But there is the policy question. If ICE will be operating in Maryland, ICE will be arresting people in Maryland who are illegal immigrants. If there are no detention facilities in Maryland, ICE will have to house them someplace. And so the likelihood, I suspect, is that ICE will quickly rush them to an airport and fly them, probably by private plane, a long way away to some other state that has detention facilities that are available. So the policy that we would be adopting if we pass this bill is that we would be making it highly unlikely that anyone arrested by ICE would ever see their families again because they would be housed 1,000 miles away unless the families could afford to travel from Maryland to Louisiana prior to the ultimate deportation of these folks, that they would literally disappear, and the families, I assume, would find out that they had been arrested, but they would never see them again. Is that a policy that you think is a good idea for Maryland to adopt?
We wrestled with that, and we made that policy decision when we did, in part, again, dignity not detention, when we said our state and local facilities would not be housing folks that were going through those removal proceedings and being subsidized by the federal government to house them. We made that decision during the first Trump administration. And obviously, this iteration of the Trump administration has gone on hyperspeed for removal proceedings and the inhumane treatment of persons here in the United States. Look, one added, so that's a kind of a decision we've already made as a state. But the important distinction here for the private entities is that any correctional facility that operates in Maryland should be subject to public scrutiny and public oversight and public inspection and public accountability. And so you get the ancillary benefit of not participating in housing people that are going through the removal proceedings, but also the ancillary benefit of having real oversight and accountability for correctional facilities that operate in Maryland.
I gather that. Certainly we could pass bills which establish much more stringent regulatory schemes which would apply to detention facilities, but this bill doesn't take that approach. No. This bill simply says you can't have private detention facilities.
That's right.
And given the fact that ICE is now, up until this point, ICE has been housing people, I gather, in the federal building in downtown Baltimore. Heavens knows how you do that in an office building. But if this bill passes, that would no longer, well, that might be possible, right? Because that's a federal building. That would not be owned by the federal government.
It's federally owned and operated.
Excuse me?
It wouldn't touch that.
So it wouldn't cover that. Okay. Thank you very much for answering my questions.
Thank you. Senator McKay and then Senator Muse.
Thank you, sir. Thank you, Chair. So in Section 2, it makes the act retroactive to prior agreements.
Yeah, talked about that, right?
Requiring permits issued and investments made. Is there any anticipated impact on existing local and state agreements with these private entities? And has the Attorney General assessed the risks that of contract impairment claims taking on litigation? And is there going to be any possible fiscal liabilities to the state?
No, so I have not, that issue did come up. I have not sought Attorney General's guidance on that. I mean, I understand the risks there, the impairment of contract that's already underway. I'm not aware of any such contracts in existence in Maryland yet right now. This is an emergency bill, so it will go into effect as soon as it's signed by the governor. Second is that there is an assumption of severability in every piece of legislation that we pass. So if this piece were to be considered unconstitutional in any way, the rest of the bill would still go into effect. And so I'm confident with leaving it in there. Just given that it's an emergency bill, I'm not aware of any other contracts underway, and that severability means that the rest of this bill would remain intact.
Right. And if I may, Mr. Chair, one more question. Ma'am, may I ask you a question, please?
Yes, please.
Thank you. You had mentioned in your testimony about water in the town of Williamsport. Just wondering if you could provide the committee with any kind of data that supports that claim.
Yes, I'd be happy to. There's a researcher in a group called Project Saltbox, and I'd be happy to provide all the data. But, you know, I think the proposed warehouse is proposed to house 1,500 people, and that requires thousands of gallons of water. If you think about in your daily use how much you use to drink, how much you use to wash, to launder clothing, cooking, things like that, it's a large use of water, and the water supply for that area is not nearly adequate, as is the sewage capacity for housing that many people has not been established at all. The building right now has 2 bathrooms, but there has not been water or sewage worked out to adequately treat that number of people. I can tell you from my review of ICE records that there are many people all over the country that are not given drinking water. As a matter of fact, they're not. And if they're given water, it's not of potable quality. The other problem is that the local hospital is called Meritus Hospital. Their emergency room, as it is, cannot handle the amount of patient care from the local population. So the doctors at Meritus have already written a letter saying that, with an influx of 1,500 people, they will not be able to handle that number of people coming into the emergency room. And ICE, by their own admission, is no longer paying for most medical care. And I can provide you the documentation for that also.
Yeah, I'm actually very surprised of those statistics, because if Washington County can't handle 1,500 people in a population, I've got a lot of work to do down here in the General Assembly. We're going to have to come up with a lot of money for sewer and water, because as Washington County does grow, the 8170 corridor, we're investing, hoping to get millions of dollars to widen 81 because of the influx of the amount of people that are coming. So I instead of this group, I think that's wonderful that this group has done some information, that kind of stuff, but they probably ought to talk to planning and zoning, because it's my understanding the water is going to be coming from the city of Hagerstown.
Correct.
Correct, and then they would be the ones that would determine if they could do the capacity or not, some other group. I'm not very close enough to it. I do represent that area, but I'm just calling balls and strikes. That the data really should be coming from government agencies of what their capacity can or can't be. So I'd love to look at your information.
I will happily follow up, and I can tell you within the past year, there was a fire in Washington County, and when the firefighters opened the hydrant, it was dry. I mean, the water's already not being adequately planned, and this will worsen the situation.
Like I said, ma'am, if that is a fire and EMS problem that we have, we certainly have a lot of work to do down here, because we are in a world of hurt. We're in a tight spot.
Senator Muse is next. Thank you, Senator McKay.
I know that in our county, I'm sure in most counties, but let me just speak for my county. In my county, the permitting process can take forever, right? I mean, it could take 3 or 4 years to get a house built, et cetera, et cetera. When they build here in the state of Maryland, are they exempt from our permitting process, or are they, or can we do something through permits?
Absolutely. I mean, first, that wouldn't be necessary, because if this bill passes, then there's a strict prohibition on any private correctional facility being constructed in the state of Maryland. So that, I think, is a more elegant approach and gets to a lot of, I think, good policy decisions or postures for our state to be in terms of not having privately run detention facilities.
And then lastly, it's just a little, we're in other countries talking about how badly they treat their citizens, and I think it's no different than what we allow here. It's awful. We don't treat people like animals, no matter who it is. So I think it's a good bill. Thank you.
Thank you. I've said it on the floor, and I'll say it here. I mean, I think there are serious human rights violations occurring in our state with these facilities, or at least there were, and then across the state, across the country, with how people are being warehoused.
Thank you, Mr. Chairman. Seeing no further questions for this panel, we'll move to the rest of the proponents. Is Alice Barrett here? Teresa Gutierrez? Please come on up. We will take your testimony. Whomever would like to go first.
Good afternoon, Chair Smith and members of the committee. My name is Alice Barrett. I'm the managing attorney at CASA for the immigration legal team. And for more than 8 years, I have worked directly with individuals and families impacted by civil immigration detention, including directly representing them in court. I'm here today on behalf of our membership in support of this critical bill. Senate Bill 984 is necessary and preventative, as it will stop the expansion of immigration detention in Maryland through backdoor means. In 2021, as was alluded to earlier, this body passed the Dignity Not Detention Act, ending local ICE detention contracts and making clear Maryland does not support profiting from immigration detention, and this was a major victory for our community. However, over the last several months, we've seen renewed efforts all over Maryland to expand ICE detention capacity in our state. You may have heard of Alligator Alcatraz, the notorious makeshift facility in Florida where immigrants are being held in cages above the Everglades, but we need not look that far, as ICE detainees have been held in atrocious conditions right here in Maryland in the Baltimore hold room. ICE has used this location designed to temporarily hold and transfer as a de facto detention facility, detaining people for as long as 10 days with no beds, insufficient bathrooms, no cafeteria, and no on-site medical care. In 2025, CASA responded to 567 ICE detentions in Maryland, and through our raid response hotline, we've documented repeated patterns of abuse, people denied life-sustaining medication, held for extended periods without food or water, handcuffed at their hands and feet for more than 24 hours, pressured to sign deportation documents, and separated from their children during routine traffic stops or check-ins. These are not isolated incidents, rather they are systemic. Maryland must not allow mass detention facilities to quietly embed themselves in our communities through vague zoning classifications or loopholes. And as we've seen in Howard County, when Maryland communities are given a voice, they consistently and bravely reject ICE detention. For those reasons, CASA urges a favorable report. Thank you.
Hello, good afternoon. My name is Viviana Lozano, and I'm good afternoon. My name is Viviana Lozano, and I'm going to be translating for Teresa.
Buenos días, mi nombre es Teresa. Vivo en el condado de Prince George, junto a mi esposo y a mis dos adoradas hijas. Soy miembro de CASA y hoy les voy a contar lo que está pasando en los centros de detención de ICE.
Good morning. My name is Teresa. I live in Prince George County with my husband and my two beloved daughters. I am CASA member, and today I want to share with you what is happening in ICE detention every day.
Estoy muy agradecida por la oportunidad de compartir mi testimonio. El día 24 de octubre del año pasado, nuestras vidas cambiaron por completo. Mi esposo fue detenido por ICE cuando se dirigía a su trabajo y como todos los días junto a sus compañeros.
I am very grateful for the opportunity to share my testimony. On October 24 last year, our lives changed completely. My husband was detained by ICE on his way to work, as he did every day with his coworkers.
Desde ese momento, nuestras vidas se han convertido en un caos lleno de incertidumbre. Él fue detenido y llevado a Baltimore, donde estuvo ahí por varios días, sin poder bañarse, cepillarse los dientes o hacer nada con su higiene personal, como tampoco un lugar privado para utilizar el baño. Eran muchos en una misma celda.
Since then, our lives have become a chaotic and uncertain situation. He was detained and taken to Baltimore, where he was held for several days without being able to bath, brush his teeth, or do anything for his personal hygiene. He also didn't have a private place to use the bathroom. There were so many people in the same cell that they had to sleep on the floor.
Eran tantos que les tocaba dormir en el piso. Nadie debe ser tratado de esa forma y nadie en el estado de Maryland debería pasar por esto.
There were so many in the same cell that they had to sleep on the floor. No one should be treated this way. No family in Maryland should have to go through this.
Una de mis hijas tiene dislexia y necesita del apoyo de su padre, y su ausencia fue muy difícil para ella. Además, mi esposo es el principal proveedor de nuestro hogar, y ahora enfrentamos grandes desafíos económicos y emocionales.
One of my daughters has dyslexia, and she needs a lot of her father's support, and his absence has been very difficult for her. In addition, my husband is the main provider for a household, and now we face a great economic and emotional challenge.
El poco dinero que tenemos se ha ido en consultas legales, tratando de encontrar una solución para traerlo de regreso.
The little money that we have is gone to legal consultations, trying to find a solution to bring him back home.
Cada vez que podíamos hablar con él, solo lloraba y me decía que se sentía solo y abandonado. Es muy doloroso ver cómo tantas familias inmigrantes sufrimos por políticas que parecen no tener compasión.
Every time we managed to talk to him, he just cried and told me that he felt alone and abandoned. It's so painful to see how many immigrant families suffer because of policies that seem to have no compassion.
Cuando lo único que hemos hecho es trabajar y aportar a este país. Somos la primera fuerza laboral de los Estados Unidos y aún así nos tratan como si no perteneciéramos y no de este país.
When all we have done is work and contributed to this country. We are one of the largest workforces in the United States, and yet we are treated as if we don't belong here.
Le pedí tanto a Dios cada día que mi esposo volviera sano y salvo a nuestro hogar, que esa petición se hizo realidad. Después de tanta lucha, él pudo salir con una fianza.
I pray to God every day for my husband to return home safe and sound, and that prayer was answered. After so many struggles, he was released on bond, even though he's free. He's still very, sorry.
Y a pesar de estar fuera, él quedó con mucho temor y pánico, y aún sigue siendo que lo pueden arrestar de nuevo y dejarnos otra vez.
Even though he's free, he's still very fearful and panic and feels like he could be arrested again.
Las dos leyes que hoy se están presentando hablan de las necesidades y derechos básicos que cualquier ser humano necesita para estar dentro de un centro de detención aquí en Maryland.
The two detention bills being here today are about basic rights, basic human dignity, and keeping prisons like this out of Maryland.
Les pido a todos ustedes que tienen el poder de votar favorablemente para que esta ley pase, que lo hagan por favor, que nosotros no debemos ser tratados peor que animales, que nosotros tenemos derecho a que se nos respete.
I ask to all of you to have the power to vote in favor for this law, please pass it. Pass it in favor, that we don't deserve to be treated as animals, that we have rights, that they need to be respected like every other person in this country.
Me despido con la esperanza puesta en Dios, en ustedes, y somos casa, para que continúen abogando por las familias que, como la mía, hoy necesitan de su apoyo y solidaridad. Gracias.
I say goodbye with my hope placed in God and in you. We are casa, so that you be continue advocating for families who, like mine, need your support, solidarity today. Thanks.
We have from Senator West.
Could I ask a question of the witness who just left the podium? Could she come back? Thank you. Your testimony was very moving. You want to translate?
Que su testimonio ha sido bien fuerte.
So I have one question for you. If the likely result of passing this bill is that your husband and others who have been arrested and will be arrested by ICE are immediately put into airplanes and flown to a detention facility 1,000 miles away, do you think that that would be preferable to the current situation where they are kept in a detention facility here in Maryland?
I'm sorry, it's very long.
I'm sorry.
I'm gonna try to translate it.
Want me to break it into pieces?
Yes, please.
Okay. If the likely effect of this bill
Si este bill te realmente afecta,
is that your husband and others who are arrested by ICE in the future
si tu esposo u otros que sean arrestados para el futuro
are put into airplanes immediately after their arrests
les ponen en un avión inmediatamente que los arrestan
and flown to an ICE detention facility 1,000 miles away,
o fuera en un centro de detención a miles de millas de
instead of being held in a detention facility in Maryland,
en vez de ser detenidos en un centro de detención en Maryland.
do you still support this bill?
Todavía sigue apoyando este bill. No necesitas contestar. Todavía sigue apoyando este bill.
No tiene obligación de
No tiene
contestar su
obligación de
decisión.
contestar. No contestar.
Porque yo quisiera decir, si él no es criminal, ¿por qué está detenido? Yo podría contestar a su pregunta diciendo, si mi esposo no es un criminal, ¿por qué es que él fue detenido solo cuando él estaba llegando a su trabajo?
She wants to reply, answer this question a different way. This, her husband, he was not a criminal while he was detained.
May I briefly add to your questions? Thank you, and I do appreciate your concern and the question directly to our member. I just wanted to make sure to add, with regard to the concern that does come up repeatedly regarding originally in dignity not detention and now in these bills that are seeking to rein in the cutting of corners and recreation of detention in Maryland. Transfers have been happening for a long time by ICE, including when we did have detention in Maryland. It, at times, unfortunately, is a tactic used to make it harder for individuals to obtain access to counsel. And moreover, what we have seen through research by the Detention Watch Project, among others, is that what in fact increases the likelihood of ICE arrests and detention is the presence of detention centers. And so it's a bit of a fallacy to tie the likely transfer of individuals to the presence or lack thereof of detention centers in a particular state. And I would also add that, in addition to bed space really being a driving factor with regard to how often people will be arrested and detained, dignity not detention was supported by our members at large when it passed. And the past year, I think, has shown us that to hold ICE accountable for its abuses of power, it is important to rein in the actions that they are taking with the tools that we have available at the state level as a measure of accountability.
I appreciate your answer. My concern is so frequently when bills like this come, we hear from advocates like you.
Yes.
Who I suspect do not feel yourself in danger of being arrested by ICE for illegally coming into this country, and do not face the potential of being detained and deported and moved from one detention facility to another. So this was my first opportunity to ask my question of someone who is actually experiencing this. If it were me and my loved one were arrested, I would want my loved one to be held close to me so I could visit frequently and not held so far away that it's unlikely I would ever see the person again. And that's why I wanted to ask the question of the lady who has been directly affected by this, rather than to an advocate like yourself who has not experienced this personally. Thank you.
Thank you, and I do appreciate that concern. I just want to reiterate that we do speak on behalf of our members, and we're a member-led, member-driven organization, and all priorities that we advocate for have been voted on and decided by members who are part of the community, just like our member who you spoke with today. Thank you.
Further questions from the committee? All right, seeing none, thank you very much. With that, that will conclude the hearing for Senate Bill 984. We're now going to move on to Senator Heddleman with Senate Bill 988.
And I think we had one witness on the panel who was virtual. It should be Rena Shaw. Great. Okay. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the JPR Committee. For the record, my name is Corinne Wisman, and I'm here today on behalf of the bill sponsor, Senator Heddleman, to present and testify in support of Senate Bill 988, Judicial Facilities, Stops, Detentions, and Arrest Limitations. At its core, this bill is about protecting Maryland's access to Maryland's courts. Our courthouses serve a unique constitutional role. They're places where individuals come to assert their rights, comply with legal obligations, participate in the justice system as victims, witnesses, defendants, jurors, and family members. For our justice system to function effectively, people must feel able to safely access the courts. However, across the country, we've seen an increasing use of courthouse appearances as opportunities for civil enforcement actions. When individuals fear appearing in court could expose them to unrelated civil arrest, it creates a chilling effect, and people may decline to seek protective orders, refuse to testify as witnesses, or fail to appear in court altogether. Reports from legal service providers and community organizations indicate that this chilling effect has been felt in Maryland as well. For example, the Access to Justice Commission found 472 instances reported where survivors of domestic violence and sexual assault did not seek protective orders due to ICE activity near courts. Senate Bill 988 seeks to address that concern in a very narrow and very targeted way. The bill prohibits stops, detentions, or arrests for offenses that carry only a civil penalty on the grounds of a judicial facility. The bill includes carefully defined exceptions that permit enforcement of actions under specified circumstances, which is outlined in the senator's written testimony as well as the bill language itself. Importantly, it does not interfere with criminal enforcement or arrests made pursuant to a valid judicial warrant signed by a judge. Those authorities remain fully intact. Instead, it establishes clear parameters to ensure that individuals can attend court proceedings without fear of unrelated civil enforcement actions. The bill also provides limited enforcement mechanisms to ensure accountability by allowing for a private right of action for violations, as well as the authority for the Attorney General to seek injunctive relief. These provisions ensure that the statute is meaningful, enforceable, and consistent with existing civil rights frameworks. I also want to note that it is my understanding we have several sponsor amendments that are either in progress or will be handed to you soon that would strike the language on page 2, line 7, referencing other areas within 1,000 feet of the courthouse, as well as striking language on page 2, lines 27 and 28, referencing individuals traveling within 1 mile of the judicial facility. The amendment removes the 1 mile radius provision so that the bill only applies on the actual grounds of the judicial facility or courthouse, which further narrows its scope. And lastly, we have an amendment request to clarify that the exception set out in subsection B2 on page 2 applies only to a valid judicial warrant, so adding the word judicial as recommended by the Office of the Public Defender. Other states, including California, Illinois, Oregon, and New York, have enacted similar legislation to preserve courthouse access. Courts have upheld these measures, recognizing that states have the clear authority to regulate the operation and accessibility of its own judicial facilities. And in these court cases, the legislation that was upheld were broader in scope than SB 988, which is more narrowly tailored and does not prohibit courthouse civil arrests outright like other states' bills, but instead establishes limited restrictions and procedural requirements governing when such enforcement actions may actually occur in judicial facilities. Ultimately, the bill reinforces a simple but essential principle. Individuals who are required to appear in court should be able to do so without fear that participating in the justice system will expose them to unrelated civil enforcement. SB 988 strengthens due process, protects public safety, and reinforces confidence in Maryland's courts. It establishes clear, enforceable rules that balance enforcement authority with the fundamental needs for accessible, functioning judicial institutions. For these reasons, the sponsor respectfully requests a favorable report on SB 988. I'll now turn it over to my witnesses on the panel who will give you more details, and then I'll be happy to answer any questions you might have. Thank you.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and honorable members of this committee. My name is Katie O'Malley. I'm the Executive Director of the Women's Law Center of Maryland, and I've testified before you all this past year on bills involving matters that we care deeply about at the Women's Law Center. We're a nonprofit that's dedicated to protecting the physical safety, the economic security, and the civil rights of men and women throughout our state of Maryland. Through our legal services policy, advocacy, and education, we work to ensure that individuals, including immigrants and survivors of violence, can safely access the courts and comply with legal obligations without fear, anxiety, and terror. When courthouses and other judicial spaces become sites of intimidation, civil immigration enforcement access to justice is fundamentally compromised. We've all heard of the federal government talking about removing violent criminals from our streets, and we've heard from so many different individuals that they've been picked up by ICE and they don't have criminal records, and some of them are actually citizens of the United States. Particularly people of color are being attacked. ICE agents have been present in and around courts and other administrative buildings where immigrants who entered the country legally are following all the required rules to get citizenship, must report for check-ins related to their immigration cases, and then are getting locked up and detained. This must stop. If we have rules that require immigrants to check in at courthouses and other administrative buildings, we must also ensure those spaces are secure and free from civil immigration enforcement. This bill, if enacted, would prohibit the detention or arrest of an individual for an alleged or adjudicated offense that is subject only to a civil penalty, while the individual is in the judicial facility or is no longer traveling within a mile, because that amendment has been taken out of page 2. It's important, I mean, for the people that we serve at the Women's Law Center, we have many foreign-born survivors of intimate partner violence. They're not coming to court, as stated by the witness already. So I urge a favorable vote on this bill, and thank you for your attention.
Excellent. Thank you both very much. Questions from the committee before we switch to our panelists joining us virtually? All right. Actually, Senator West, let's hold off since they're both all proponents of the bill. Let's go ahead and hear from Ms. Shaw first, and then we'll go to Senator West for his question.
Good afternoon, Chair Smith and members of the committee. I am Rena Shaw, the Executive Director of the Maryland Access to Justice Commission. We are here in support of SB 988 and request a favorable report. As the name of our organization suggests, we believe that justice must be accessible. And for the justice system to function, judicial facilities must be viewed as safe, neutral, and an impartial forum. Obviously, these facilities are used to protect themselves. People use them to protect themselves and their communities from harm and to exercise fundamental rights. And we cannot have the prospect of people just opting out of this forum. And what I want to add, because a lot of what I was going to say has been said, I will just add that beyond sort of domestic violence and protective orders, immigration-specific cases, we are hearing from sort of advocates in many different areas where this affects everything from tenants who will not file an escrow, or fight for their heating to be turned on or for their mold to be remediated. People may not be exercising their right to go and fight wage theft because they're fearing going in or even applying for unemployment. So I just want to say that, the types of cases that are involved where people feel fear and may not be availing themselves to court processes or administrative processes is so broad that it has a vast impact. So we want to make sure we highlight that. And we also want to highlight that, these places are not only where justice is adjudicated, but where people can really access vital services. And when they don't access those vital services, it can have ripple impacts on housing stability, economic security, and personal safety. So we wanted to contribute that, and we really request a favorable report. Courts and administrative hearing spaces and other areas should be safe and neutral. Thank you so much for your time.
Thank you very much, Ms. Shaw. Good to see you. All right, we have Ms. Barrett. Is Alice still here? And Christine Horn. All right, go ahead.
Okay, thank you.
Steve.
Good afternoon, Chair Smith and members of the committee. Once again, my name is Alice Barrett, and I'm here on behalf of We Are CASA as Managing Immigration Attorney in strong support of Senate Bill 988. Thank you, Senator Hedelman, for your leadership on this bill. We Are CASA supports the bill because it protects the integrity of Maryland's courts by limiting immigration enforcement actions inside courthouses. Courts must remain places where people can safely participate in the justice system, whether they, like many CASA members, are victims seeking protection, witnesses sharing information, or individuals resolving legal matters. It's simple. When people fear being detained by immigration enforcement while attending court, it discourages participation and undermines the fair administration of justice. Ensuring that people can access the courts without fear strengthens due process, promotes public safety, and supports the orderly functioning of Maryland's judicial system. When community members feel safe appearing in court, cases move forward more effectively. Victims and witnesses are more likely to come forward, and judges can administer justice without disruption. Maryland has a clear and legitimate interest in protecting the operation of its courts, as states have long had the authority to regulate conduct within their judicial facilities to ensure that court proceedings can take place fairly and without intimidation. SB 988 advances that goal by establishing clear boundaries around immigration enforcement within courthouses. I do want to note that we recommend a few targeted amendments to strengthen the bill and help ensure it is legally durable. Most importantly, the bill should clearly require a judicial warrant for any arrest inside a courthouse rather than allowing administrative warrants that are not signed by a judge. We also recommend clarifying the distinction between courthouse facilities and surrounding public spaces and narrowing some of the current exceptions so that they can't unintentionally undermine the bill's purpose. And of course, we'll work with the sponsor on these items. CASA is proud to support this bill and looks forward to working with Senator Hedelman and the committee to ensure it is as strong and effective as possible. Thank you for your time.
All right, I think we have one more guest, Steve Buckingham. Is Steve here?
Sure, thank you.
We'll hear from Steve, and then we'll open it up for questions.
Thank you, Mr. Chairman. Senator Fulton, my senator, and members of the committee. I'm Steve Buckingham. I'm an attorney from Frederick. It was worth going through the snow to get down here today, but this is the first time I've testified this year.
We've been stuck in this tomb here all this.
Yeah.
We don't even know it's snowing, so.
Well, it stopped snowing. It's all rain now.
Okay, I appreciate that. We'll restart your time. Go ahead.
As an attorney and someone who's been in the justice system for over 50 years, I'm frankly offended by what's going on in our courthouses across the country because of what's going on with immigration enforcement. Immigration enforcement is a lawful and appropriate process for the federal government to do. However, the way they're going about it is in danger of turning our courthouses into the local Home Depot, where ICE agents wait outside or inside and snatch up anybody they think is an immigrant or looks like an immigrant, and whether they're there for criminal cases or not. The whole idea of due process is you don't get searched or seized unless there is a specific reason to do so. You don't round up people. In a courthouse, It is the home of the law, whereas as Muslims go to their organizations, churches, synagogues, and are all houses of God. That courthouse is the house of the law, not of God. And we need to protect it. We have a duty to do that. Immigration enforcement has been out of hand. It has been extra legal and no due process granted to those people. People think that courthouses are all for criminals, that the only people go to courthouses are for crimes or criminal justice. There's traffic cases, there's civil cases, there's rent cases. Witnesses show up. In fact, immigration has also allowed people who are witnesses to crimes or victims of crimes. I think it was Senator West, it was your bill, the youth types of provisions that allow someone to avoid being deported if they're there to pursue or contribute to a legal case. But they've forgotten all of that now. And people are, who are there, families in support of witnesses, in support of victims, are all subject to the same kind of tactics.
Thank you very much, Mr. Buckingham. All right, question. Senator Muse has the first question.
Thank you, ma'am. May I ask you a question?
Yes.
What's the value of requiring judicial warrants for arrest in a courthouse without prior notice?
I'm very glad you asked me that question. One of the key differences between a judicial warrant and an administrative warrant is that ICE essentially creates administrative warrants and signs off on them themselves. So there's just not the same accountability or specificity in them that would ensure that there has been oversight by a neutral judge who can verify that the alleged grounds for arresting this individual is in fact appropriate. And so it would lower the baseline of who can go in, who can be arrested within the courthouses without any prior notification as required otherwise under this bill, to the same level as who can be arrested in the streets, right? And so it would defy much of the purpose of the bill of heightening the standard. We've seen, for example, in the Escobar Molina litigation in Washington, D.C., that even that very minimum requirement of using administrative warrants is not being respected now with the quota-based system that is driving agents to make these arrests broadly based, on racial profiling and other factors. And so at minimum in a courthouse, in order to get around the prior notification to the courthouse officials, in order to carry out an arrest, a judicial warrant, a proper warrant should be required.
And then just one additional. In our state, I believe we have laws against racial profiling. Would they be amenable, no, not amenable, would, if we were to go to court and ask them and say, even from us down here, that you can't arrest somebody for that reason, are they accountable and can we do something about it when we know that's the case?
Well, yes, I think that the Escobar Molina litigation actually is a great example of that. So there was a preliminary injunction granted in that matter in D.C., where we've seen the greatest targeted surge in our region to date, that basically prohibited warrantless arrests without further either the baseline administrative warrant or a further inquiry into whether that individual is in fact unlawfully present in the country and if they pose a flight risk. And so they have to make some more specific questions and not just say, oh, this person looks as if they might fit the profile. So we would certainly hope that, should a similar pattern emerge at that level in Maryland, that similar litigation could be brought.
And I
yes.
promise this is the last one.
Yes.
There is nothing in place that would say if a person says, I am a citizen, that they must be brought before our courts to authenticate that or not. Anything in place for that, or they just ignore the law and do whatever the heck they want to do?
I'm not sure that I could point to specific legislation that I'm aware of that would require proving one's citizenship in order to just make the assertion if it is in fact true. However, there are many laws prohibiting false claims of citizenship, and there are penalties for that. So if someone who's not a citizen claims to be a citizen, that is penalized under immigration law and other laws. And we have been sadly recommending that U.S. citizens who are naturalized, for example, carry their passports on them in this day and age just because of the reality that we're facing.
Thank you very much.
Thank you.
I think my questions are things that we can answer later, but I am just very unfamiliar with a lot of what's being discussed. For example, judicial warrants versus administrative warrants. I know there's other bills in which we're trying to make some changes here, but until I fully understand the import of both kinds of warrants, how they're done, what their purposes are, I'm very uncomfortable deciding which are and are not going to be upheld or enforced. So,
do you want me to answer that question?
Well,
the
to a
difference?
limited extent, because
Right.
because I'm not going to take
So,
anybody's
I'll just give you a
particular
hypothetical. I don't want to interrupt you, I'm sorry.
meaning. In other words, I really want to get a completely unbiased, almost like, I'd like to hear this information from somebody that's not testifying for or against these bills, because that's where I find the most accuracy. But you're welcome to briefly.
So a judicial warrant is a
I understand, it's from a
neutral magistrate that reviews an agency, like the
Could be
police department.
neutral,
So if the
could be
Baltimore
biased
Police
itself.
Department wanted to search someone's home, they would go to a judge, district or circuit judge. They would have to have probable cause in the four corners of that warrant, and they would have to have a nexus to what they're going to be searching. If the Baltimore Police Department didn't
And
have
that's
to go.
enough. So then look, go.
Right, and that goes to a neutral magistrate, not a part of the
I
Baltimore
understand.
Police Department.
So administrative.
So what if it had been, though, that that's not
So
a
just
rule?
give me the meaning of administrative warrant.
Administrative is an agency. So the ICE, Homeland Security can write their own warrants, and it's an administrative warrant. So there's no oversight over that
Do
agency.
they have probable cause?
They probably do. They put that in there, but there's nobody monitoring.
So
There's
that's why
nobody.
I just need somebody
yeah.
who's really, really
It would be
informed
like
in
if-
this. I appreciate this.
Yeah.
I do.
It would be like the Baltimore Police Department issuing their own warrants and not having any oversight.
I assume if they are
Yeah.
this unfair, wrong, and able to be this utterly disrespected and disregarded, that probably we should not have administrative warrants anytime, anywhere, anyplace. So all I'm saying is I just need to get some non-biased, non-involved.
Well, I just know from signing
So I will
warrants for
follow that
20
up with the
years,
chairman. The other thing is we can do this later too, which is just, I know we passed some legislation about sensitive places. We don't have to do a tutorial now. But again, I thought a lot of that was to get ahead of and protect places. Also carefully, thoughtfully doing it so that we don't run afoul of other priorities and legitimate purposes of all levels of government. So maybe talk about that later. And then just for some clarification, I think anybody could answer this one question. Just, I understand people go to court for all kinds of purposes. I'm a lawyer myself. But just so I understand one thing, if you're going to court for an immigration purpose, that would be a federal court, right? We don't have state, I just want clarification, not a dissertation. You don't go to state court to deal with any kind of immigration, either whether it's to check on your asylum, get your green card, or do anything. Is that correct? That's correct. Okay, so we're worried about people that might go to a state or local court for things that are purely state and local, but might become, federal enforcement and ICE people could be aware of those in some, I guess because it's public record, I guess, and then could use that opportunity to. Last question, though nothing in this bill once limited about the 1,000 feet, because the judiciary is quite smart about, we can't control that, nor a mile, clearly. Nothing in this bill would prohibit federal law, ICE, and immigration enforcement to, be on private property or public property a little further away from the court. Okay, just right, because that is beyond the reach of any of us. All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. So I'd like to ask questions of someone who's familiar with the bill. If Judge O'Malley is familiar with the bill, I'd love to ask her questions. I'm not sure I've ever directly questioned her before. and I'm not going to be here much longer, so this will be my last chance.
No, you certainly have asked me questions before.
I can't remember.
And if I can't
That's why
answer-
I'm leaving, because I'm getting old. So I'm trying to figure out who the bill applies to and who it doesn't apply to. And as I look on page two of the bill, this along section B that says this section does not apply to a stop, detention, or arrest, and then there are 7 subcategories. As I go through the subcategories, it appears to me as if it effectively excludes everybody except federal agencies. Am I correct in that?
So you're asking what this doesn't apply to, as far
Yeah.
as criminal cases and
It doesn't apply to.
in Section B of the bill?
And then 7, otherwise authorized under state law. So it seems to me as if what it says, cutting through all the verbiage, is that the only organizations that this bill applies to are federal law enforcement agencies.
Yes.
You agree?
And it says the person includes a law enforcement agency, law enforcement officer, and any other government agency or government agent.
Right. So it appears that all state law enforcement agencies are permitted to go into courthouses and arrest people, but
not on for immigration purposes, yeah.
But federal law enforcement agencies under this bar not.
Correct. So if the person is there, though, because if they're there for just to access justice, if they're there for a matter not involving a criminal matter, not involving, if there's, like I said, a valid judicial warrant, then ICE could still go in and serve that valid judicial warrant. And also there's these exceptions that I looked at that are part of courts and judicial proceedings, if there's an issue about taking a child into custody, if there's a missing persons issue. I mean, so it gets into kind of some more very niche sort of exceptions. But it's, again, towards going in and trying to...
If ICE were to get a federal judicial warrant, then ICE could go into a state, under this bill, ICE could go into a state courthouse and arrest someone that's named in the federal judicial warrant in the state courthouse.
Yes.
But other than that, neither ICE nor the FBI nor any other federal law enforcement agency would be permitted to operate and arrest people in state courthouses, while state law enforcement agencies would be able to. Is that a correct reading of the bill?
Yeah, I mean, I think so. I mean, I'm trying to weed through it. It's the purpose. They're supposed to be not going in there to pick up people for detention, for federal detention,
the reason
for
I'm
immigration.
trying to ferret this out is I find much of what ICE does to be reprehensible and appalling, frankly, and I'm no friend of ICE, based on how they're operating currently. But even though I would like to push back against ICE, I don't think the way to push back is for us to engage in unconstitutional work or pass unconstitutional statutes. And maybe could either of you comment, if I'm correct in my analysis of this bill, that it differentiates between state law enforcement agencies, which are permitted to do these things, and federal law enforcement agencies, which are not. Would you care to give me an explanation as to how that squares with the supremacy clause of the U.S. Constitution?
Just wanting to chime in, but I will preface that I'm not a supremacy clause expert. However, I think that with regard to your concerns, which I understand get at kind of content neutrality and not wanting to just single out one federal agency, perhaps through a bill, I believe that exception number 1 about relating to a suspected criminal offense, which we do believe should be narrowed in other ways, doesn't just relate to state enforcement. So I think that would allow for...
I'm sorry, where are we talking about now?
Oh, under, at line 14 and 15. So if you're looking at the categories of exceptions, I understand you're looking at B7, otherwise authorized under state law. So that seems to relate to state agencies specifically. But relating to a suspected criminal offense, for example, I mean, that in my mind encompasses law enforcement by federal criminal law enforcement agencies, such as the U.S. Marshals, the FBI, right? We do think that that provision should be narrowed because it could create a loophole since ICE is, using the narrative that all of their immigration enforcement relates to an overbroad interpretation of criminal offenses. However, I believe that there are exceptions here that apply to both federal and state agencies.
All right, well,
When you look at that one as an example.
That's very helpful. But then, so what this bill is limited down to is trying to stop people, law enforcement agencies from arresting people or stopping people in connection with civil penalties.
Exactly, and
Now,
that.
so let's
yes.
just talk about that for a moment. Am I correct that under this bill, state law enforcement agencies would be able to go into courthouses and stop people based on civil penalty offenses, but federal law enforcement agencies would not be permitted to go into state courthouses and stop people for civil penalty offenses?
I don't think that it's as simple as that. I would say that, I mean.
Well, that's why I'm having trouble figuring
Right.
out what this bill is all about.
Sure. I mean, I think that the distinction.
Is this
sure.
really a bill which is trying to get at ICE and ICE only? Or are, the bill is written in such convoluted language, it's hard to tell exactly what the bill covers and what it doesn't.
Well, there are specific carve-outs here for certain, it appears, civil arrests. So the ones that they're not currently described in further detail, but for example, exception number B3 relates to taking children into custody under a custody order, orders on conduct before the court. So if people are acting out of line in a courthouse, and then I know that subitem 6 relates to involuntary admissions to health institutions. So I think there was some conscious selection here happening with regard to civil matters where it is believed that those would be right in the public interest to make exceptions for. However, I don't see there being a broad carve-out that would allow any type of civil state-based arrest in a courthouse without prior notification. I think that the distinction that you're seeing throughout the bill is between civil and criminal for good reason, right? Because we would want more protections around offenses that are merely civil. However, it doesn't appear to be drawing a broad line between state and federal agencies in the way that I believe your concern was expressing.
Okay.
I don't know if my colleagues have anything to
Thanks
add.
for your I still as confused as I can be about exactly what the bill covers and what it doesn't. But I guess I've gotten the best information I can from you. Thank you.
I can make one comment really quickly about your question about the supremacy clause, and I will preface with I'm not a lawyer. So this is just based off of the research that we've done. But there was a similar piece of legislation in New York passed in 2020 called the Protect Our Courts Act. And it was argued by, or the United States federal government filed a lawsuit arguing that it alleged preemption, unlawful regulation of the federal government, and discrimination against the federal government per the Supremacy Clause. And in November of 2025, a federal district court dismissed that case, saying that there was no violation of the Supremacy Clause. So I am not.
Was that subject for written opinion?
Sorry?
Was there a written opinion issued in connection?
There was a written opinion.
There was? Do you have a copy of the written opinion?
I don't, but I can get it to you.
That'd be great. I'd love
Yes.
to take a look at it.
Yep.
Thank you.
All right, thank you very much. Let's just, it's okay. All right, further questions from the committee? All right, thank you very much. With that, that'll conclude the hearing for Senate Bill 988. Let's go on to Senator Charles with Senate Bill 965. Yeah, we're going to take a 5-minute.
All right. The final bill of today and the final bill of this year and the final bill of this term is SB 965. Senator Charles.
Favorable. This bill has already passed the House, so we'll be getting that bill very soon, very soon. For the record, it's Senator Nick Charles on Senate Bill 965. The bill is titled Motor Vehicles Out-of-State Drivers Automated Enforcement Out-of-State Driver Accountability Act. Good evening, Chair Smith, afternoon, Chair Smith, Vice Chair Wallstreicher, and honorable members of JPR Committee. For the record, this is Senator Charles, representing District 25 in Prince George's County. Traffic safety should not stop at the state line, yet today in Maryland, that is effectively what happens when a dangerous driver from out of state repeatedly violates our traffic laws. Our enforcement system often lacks the tools to ensure those violations are properly tracked, reported, and ultimately enforced. In 2025, Bike More, a Maryland-based bicycle and pedestrian safety organization, released a report highlighting just how serious this gap has become. 6 of the 10 drivers with the highest number of speeding citations captured by Baltimore's automated enforcement system had Virginia license plates. Go figure. Collectively, those drivers accumulated thousands of dollars in unpaid tickets while continuing to travel our roadways. These are not isolated incidents. They represent a structural weakness in how we document and share enforcement data involving our out-of-state vehicles. Senate Bill 965 addresses this problem in a practical and targeted way. The bill requires county and municipal traffic enforcement programs to submit reports to Maryland's Vision Zero coordinator identifying out-of-state citations issued, including the license plate number and payment status of those violations. With accurate and consistent reporting in place, Maryland can more effectively coordinate with neighboring states to ensure these violations are properly recognized and enforced. The mechanism for the coordination already exists through the Driver's License Compact. This bill simply ensures the information is necessary for the system to function is actually collected and shared. A 2023 study found 43% of the out-of-state speeding tickets issued on Interstate 83 were accounted for, leaving 22,000 unpaid on just one of our state highways. At a time when our state is facing significant fiscal pressures, it is difficult to justify allowing thousands of dollars in traffic penalties to remain uncollected simply because the vehicle involved crossed the state border. Accountability on our roadways should apply to every driver, regardless of where their license plate was issued. Senate Bill 965 strengthens our ability to enforce the law fairly, recover revenue that is rightfully owed, and protect Maryland residents from repeat offenders who continue to put others at risk. We are also happy to adopt the House-passed amendments to align the reporting structure and ensure consistency between the chambers. It changes the reporting from annually to quarterly. Municipal stakeholders have indicated this adjustment will make implementation easier for local jurisdictions while still achieving the core goal of improving data collection and accountability for out-of-state drivers. For that reason, I respectfully urge a favorable report. As I stated already, this bill has already passed the House. It is on its way over here so we can pass the Senate version and the House version.
I'm not sure that line of argument. If you've seen, not this bill, some of the other House bills, Senator Love.
Thank you, Mr. Chair. Sorry to keep us all here, folks, but I have a couple questions. So earlier we heard a couple bills on reciprocal agreements regarding these citations. How would this interact with those?
Honestly, I'm not sure how it would interact with those right now. This is more of a reporting mechanism right now so that we can track to see what's happening. When folks are, excuse me? Sorry. Yeah. Yeah, so it's more of a reporting mechanism. So.
Okay, and then my second question is, what happens with the information if this were to pass and the registration plate and registration plate number and state of registration is sent over? Where does that information go? Because I don't we wouldn't want that stuff posted online or.
No,
I'm
it just
concerned
goes
about the
to
privacy.
Maryland Vision Zero Coordinator to identify the out-of-state citations. They keep track of all of this information. I don't believe it's going to be posted online anywhere, but it allows for our state to figure out why we have so many out-of-state vehicles that are constantly getting tickets and not paying them. We should be collecting these fines. We have folks coming in our state from Virginia, and that's been what I've said in my testimony. We've seen license plates from Virginia have more speeding tickets than some of our own people in our own communities, and they're not collecting. They're not collecting these fines from these folks.
Sure, thank you. I hear that, and I know it's an issue that we deal with a lot. I'm just very concerned about what happens with that information. So we can follow up. Thank you.
Yep.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Do you see that this bill is going to create any more administrative work for, say, the counties that operate automatic enforcement programs?
I don't know if it's going to create more work for them, but it'll definitely allow for them to see those who aren't paying the fines and see it across the board. Because it could be that somebody is speeding through my county, then they end up in your county, speeding through your county.
They're going real fast.
Yeah, very
We're not
fast.
right next to each
Getting
other.
right there, right there. So just tracking that information across the board and how many times these folks aren't paying their penalties within our jurisdictions. So it's just a way to capture, track the data, and figure out how we hold these folks accountable.
Okay, if I may, Mr. Chair. So since this is our last bill of our JPR for this session, do you agree with me that Senator West should be the last person to ask you a question? And for posterity and all, I just think that that is the right thing to do to honor all of the years of service that he has given to this committee.
He definitely should, and I think his questions are always so hard. And I've always had to do my homework and study before I get before him. So
Yeah, well, just like a chapter book, we're closing a chapter here. Yes, we're going to hear some House bills, but I think it's important that we probably end with a very, very well-established senator who I look up to. So thank you.
So I hope these aren't hard. And that's why I was talking out loud, because I'm trying to take this through. Just a couple of clarifications. So this is not trying to capture the automated traffic enforcement tickets that the state does. Is that right?
yeah, this is capturing pretty much all speeding tickets.
Okay. See, what I don't understand, if you want to know, I know we have state roads and county roads, and then we have roads and towns. And I know that different entities issue different traffic. I think the state can do it. I think the county can do it. I think the locals can do it. And I'm not trying to, I just want to understand your bill. I do not know currently how that all works, how that data is all collected. But I do think you had access to some information already about, you know, I think you told me 83 had 20, I'm making this up, 22,000 unpaid tickets. So somebody's collecting the data. So not right now, but I kind of want to understand how this bill would work with state tickets, county tickets, local tickets, and the data that we already collect at either the state, the county, or the local. Any like cost, if any, there might not be any cost for the state or county or locals. And then I think just following up, so I don't want to duplicate Senator Love's question, but in a way I'm like, okay, so we have this information. Sounds like we know 83 is a big offender. We already know Virginia's got, I think we have like 100,000 people that already are now registered in Maryland and are getting tickets. I know this, we could get this data, but I don't know if, does this data trigger anything in existing law that would then help us enforce getting payments from out of state, which is a very tricky problem and is, I don't think is addressed in this bill, and I don't want to get into it, but I do know why it's tricky. So I just what is your thoughts about that?
So
just
I'm
state,
gonna answer, I'm
local.
gonna answer the first question
Yeah,
that you had.
tell me what the state and local stuff.
So we got this is gonna address county and municipal automated traffic enforcement programs. So we're coming from traffic control, signal monitoring, automated railroad grade crossing, school bus cameras, stop sign, we just recently passed the stop sign camera system, the speed monitoring system, the look down, up and down the roadways, the county governments and the county governments have now gained control of where they want to put speed cameras, which I know my good friend does not like the cameras, but they have cameras.
Is that state only then only on local roads?
So this is county, the way the bill is structured right now, county and municipal automated traffic enforcement programs. And so also bus lane monitoring systems, the work zone speed control systems. There's a new bill that we passed, I believe, last year with Senator Washington, the noise abatement monitoring system, the vehicle height monitoring system, and any other county or municipal automated traffic enforcement systems. And
so the states are different. The state tickets are
right.
Then do you know? Then that's good to know. Are we modeling this after how the state must then collect this data already, and that's why we're asking the counties and the locals to go ahead and do the same thing? Is that correct?
I'm not familiar if the state is actually tracking this, but we do have some data that shows at I-83 how they have.
Yeah, like 95, Route 80.
All of the different.
In other words, we're asking the state, the county and locals to do it. I'm assuming we don't have the state in here because the state is already collecting the data on who is not paying state tickets.
That could very well be true.
Huh?
That could very well be true. I can get back to you on the answer.
Yeah, that's what I'm trying to figure out.
Yeah, let me get back to you on the answer with that one.
Thank you.
Yeah.
Very good. And then we'll figure out how to, if this would trigger any kind of enforcement.
Yep.
All right, thank you. There you go. Chris.
Mr. Chair, this question, Mr. Sponsor, can be answered with a single word, probably either yes, no, or maybe. And the question is this bill constitutional?
Maybe.
All right, that is the perfect way to end our Senate hearings for the year. And the last question asked of a senator for the term and for his career is Senator West. So there you go. That's right. We'll have more hails and farewells as the year comes to a conclusion. But that'll end the Senate hearings for the day and for the year and for the term. Tomorrow we have voting at 9 a.m.